know? So watch your behavior as well. Don't talk to your neighbors like they're friends anymore.
That's right. Don't talk to your neighbors, don't talk to your family.
Don't give any information about your personal life to anybody, because that information, you know, even if it's good information, you think, hey, you know, this is fine, I can tell somebody this, it can get twisted before it gets back to the, you know, to you in the courtroom.
And not only that, if you're telling somebody about your personal life and how this has affected you, well, maybe social services has contacted them and they're not telling you that. And they're saying, oh, well, now everything makes sense. Now I see, you know. These
are some of the reasons why Alvin and I decided to represent ourselves a good portion of the last 4.5 years, because we found that although, you know, not in every case, but in a lot of cases, lawyers wouldn't say and do the things that we wanted them to say and do in the courtroom, and we would end up not getting what we wanted. Lots of lawyers are, you know, sure, just consent to this, and, you know, that's the easiest way, that's the only thing the judge is going to allow. Don't let yourself regret doing something. Don't go at, you know, because at a future court date, you may very well regret that, because another judge will say to you, well, why did you consent at this time to this?
Yeah.
And you're thinking, man, I only did that because they said that was my only option. It isn't your only option.
Yeah, your lawyer's working for you, so you better inform yourself so that you can inform your lawyer in which direction you want to go. But
if it doesn't go that way, you know, you may have to, don't let
you
the
can
lawyer
represent
coerce
yourself.
you. No, you can't, not all over the place. I mean, I've run into it where I was representing myself all the time. Went to court one day and the judge said to me that I couldn't speak because I had no representation, yet he let my ex-husband speak, who also had no representation.
Yeah, that's true.
So you never know, just play by the rules so that you're never the one that's at fault or in the wrong. And that way, you know you've done your best. And if you do get a chance to talk to the judge, always make sure that it's clear, concise, don't get emotional.
Oh yeah,
and make sure you get your point out as quickly as possible. You know, think of the 3 main points that you really need to say to the judge on each court date, and try to get those out somehow. Ask permission to speak and get them out.
Most times the judge will let you speak after the ministry has babbled on for how bad of a parent you are, and how the community's concerned about your mental health or whatever they have. Usually afterwards, if you ask a judge to speak, you will be able to speak. Now, the reason that the ministry goes first is because they're trying to get you riled up.
No, the reason the ministry goes first is because whoever makes the application goes first. In the case when your child has been apprehended,
they make the application.
They make the application, but you will have opportunity to speak first when you make the application. And once you start, if your child's apprehended and at first you're only getting, supervised visits and they're so scarce that you hardly see your kid anymore, you're going to start wanting to make applications to the court. You're going to start wanting, once you see the bond between you and your child starting to diminish, you're going to start getting a little excited about it, and you're going to start trying to think of ways to get out of it. And you can apply to the courts to increase your access, or, at least we've been able to do that, and in some cases we've gotten what we've asked for, in some cases we haven't. Depends on how happy of a judge you get.
But you have to try. I mean, these are your children, and to just rely on the law firm who's going to be representing you. And let's make something clear. If you're with legal aid, you have 10 hours for that lawyer to do research. Okay, we've heard from other people that if you have legal aid, that you have 10 hours of time that's billable for that lawyer to look through all the documents. Now, by the time that you get there, they could have a stack of documents like this. He needs somebody to look those over and then brief it down so that he can get all the valid points. Well, that 10 hours could be used up in the first time that you actually get to go to court, but you're going to be going to court for years. And so all the rest of the time,
you have to do the footwork yourself.
you have to do
basically.
the footwork yourself. You got to point out all the mistakes.
Read every document that the ministry ever gives to you. Read
You have
all
to.
your disclosure, every page, even if it's ridiculous redundant, because you never know where. I mean,
Oh, well,
our
we
disclosure, we got a stack of papers like this, huge mess, and I mean every second or third page was identical to the one before.
That's right. They just keep
So-
repeating and repeating and repeating
And a
information.
lot of information wasn't in our disclosure that should have been, because we had it in disclosure in previous cases and know that it was applicable and should have been entered into this disclosure. Some people we know didn't even get disclosure until the day of their trial, the very day. And in, other cases
How are you
like
going to
my
prepare?
own, I didn't get disclosure until 3 weeks before court date. So then I get the disclosure and they're making all these allegations about all kinds of different things that had to do with police records and medical records, and I didn't have time to order either, so that I could build a proper defense for
And it
myself.
didn't matter anyways, because
The judge threw out all my
Yeah.
witnesses. She wouldn't let one of them speak, and I never got a chance to say much myself. She said, that particular judge that day said she didn't care whether the allegations were true or false. My daughter was going to be staying in care whether I consented or she was forced to find her in need of protection, even though the allegations the ministry had made about me were totally false, and I had the proof to say otherwise in the form of doctor's letters.
Yeah.
So be careful, because they don't always play fair in
No.
our experience.
No.
So, and that's, we were just going to talk about what we've learned about the etiquette of court, so I just want to say a few things about that. Like, we were talking yesterday about how people bow down to the judge when you're entering and leaving the courtroom. I was told by one lawyer that only lawyers really technically have to bow down, but I don't know if that's true, but I don't bow down to the judge anyways, and just hope that they, think that I don't know better. But the reason I don't bow down to them is because, why should I? I'm not a lawyer. And it just doesn't feel right bowing down to people.
Good point. Yeah.
But, so you're supposed to bow to the judge, but I stand when he walks into the room, obviously, and everything, but I just don't bow like everybody else does.
When they leave the courtroom.
And you're
or
not
enter the
supposed to
courtroom.
chew gum, you can't have any drinks in there, and like I said,
No
composure.
talking.
Even if you're not the one who's being heard at the moment, you're just sitting in the court waiting for your name to be called, look composed and have that pretty smile on your face.
Yeah.
And there'll be social workers all around you, you can kind of feel them.
Yeah.